So the topic for today we have is how to draft a police complaint that gets action. So many a times क्या हो जाता है ना कि we go to police and they don't get a FIR और registered वगैरह, हमें complaint नहीं देते. So उस टाइम हमें क्या remedy हो सकती है, हम क्या कर सकते हैं, the procedure, तो वो आज हम समझेंगे. So in this webinar we are going to understand कि what is a complaint, the key terms जो हम as a common man interchangeably use कर रहे थे, but in the legal field उसके बहुत ज़्यादा difference होते हैं, and every term has a different meaning. And after that we are also going to understand how to draft a police complaint, how to get it filed, and उसके अलावा जो भी important topics है उसके related we are going to understand in this webinar. So starting with this, what is a complaint? अगर हम इसको सिंपल टर्म्स में समझे, सो एक कंप्लेंट जो होता है ना, इट इज़ एन एलिगेशन जो हम लगाते हैं अगेंस्ट अ पर्सन नोन और अननोन, कि दैट पर्सन हैज कमिटेड सम ऑफेंस एंड वी प्रे टू द मजिस्ट्रेट और द कोर्ट कि आप इस पे कोई एक्शन लो. दैट इज अ कंप्लेंट. इट इज अ सिंपल मीनिंग. सो इट इज एन एलिगेशन. सो जो कंप्लेंट है वो सेक्शन 2H ऑफ द भारतीय नागरिक सुरक्षा संहिता 2023, एंड अगर हम ओल्ड एक्ट की बात करें तो इट इज सेक्शन 2D ऑफ द कोड ऑफ क्रिमिनल प्रोसीजर में डिफाइन किया गया है. सो अगर इसमें एक टिप दूं मैं, तो अगर आप कोई भी बैरेक्ट उठाते हो तो जिसका भी सेक्शन 2 जो रहता है ना, वो हमेशा डेफिनेशंस पे रहता है मोस्ट, टू अंडरस्टैंड कि पूरा एक्ट क्या बोलना चाहता है, उसकी क्या एप्लीकेबिलिटी है, उसमें क्या टर्म्स है. तो आप सेक्शन 2 अगर अच्छे से पढ़ लोगे ना तो आपको अच्छे से समझेगा. सो रीडिंग दिस डेफिनेशन, कंप्लेंट मीन्स एन एलिगेशन मेड ओरली और इन राइटिंग टू अ मैजिस्ट्रेट with a view to his taking action under this Sanhita that some person, whether known or unknown, has committed an offense but does not include a police report. सो यहाँ पर कुछ इंग्रेडिएंट्स है, जो मेन इंग्रेडिएंट्स है जो कंप्लेंट को बनाता है. सो सबसे पहले जो कंप्लेंट होगी वो कहाँ जाएगी, मैजिस्ट्रेट के पास जाएगी. सेकंड, या तो वो ओरली हो सकती है या तो वो इन रिटन फॉर्म में हो सकती है. थर्ड, यहाँ पर हम जो कंप्लेंट है हो सकता है नोन या अननोन पर्सन, हमें नहीं पता है कंप्लेंट किस, सॉरी, ऑफेंस किसने किया है. तो इट कैन बी अगेंस्ट अ नोन एंड अननोन पर्सन. एंड यहाँ पर कोई ऑफेंस कमिट हुआ है जिसके लिए हम यहाँ पर एक मैजिस्ट्रेट को रिक्वेस्ट करते हैं या तो प्रे करते हैं कि वो इस पर कोई एक्शन ले, डायरेक्शंस पास करे फॉर द पुलिस टू रजिस्टर द FIR. सो मैनी टाइम्स व्हाट हैपेंस ना, एज अ कॉमन मैन हम ये समझते हैं कि कंप्लेंट, FIR, NCR ये सब सेम टर्म्स ही है, बट नो, उसके बीच में बहुत ज़्यादा डिफरेंस है और हर एक टर्म की अपनी एक यूनिक डेफिनेशन है. सो FIR क्या होता है, इट्स अ फर्स्ट इन्फॉर्मेशन रिपोर्ट. सो इसको समझने से पहले एक बेसिक टर्म समझ लेते हैं कि कॉग्निजेबल ऑफेंस होता है, नॉन कॉग्निजेबल ऑफेंस होता है. सो जो कॉग्निजेबल ऑफेंस होते हैं ना वो सीरियस होते हैं इन नेचर. उसमें जो पुलिस है उनको परमिशन की जरूरत नहीं होती है बाय द मजिस्ट्रेट टू कंडक्ट इन्वेस्टिगेशन एंड टू अरेस्ट समवन. तो वो जो होते हैं जैसे रेप, मर्डर, ये सारे सीरियस ऑफेंस होते हैं, ये कॉग्निजेबल होते हैं. वेर इज नॉन कॉग्निजेबल ऑफेंस जो होते हैं वो होते हैं लेस सीरियस इन नेचर, जैसे डिफर्मेशन हो गया, पब्लिक न्यूसेंस वगैरह. सो वो लेस सीरियस होते हैं. तो वहां पर पुलिस को क्या रखता है, परमिशन रखता है फ्रॉम द मैजिस्ट्रेट टू कंडक्ट द इन्वेस्टिगेशन, या तो किसी को अरेस्ट करने के लिए भी वहां पर उनको वारंट इशू करवाना पड़ेगा इसके लिए. सो जो FIR होती है ना वो हमेशा कॉग्निजेबल ऑफेंस में होती है. ठीक है. और इसका जो सेक्शन है वो है 173 सब क्लॉज 1 ऑफ द BNSS. यहाँ पर जो पुलिस होती है वो इन्वेस्टिगेशन कंडक्ट कर सकती है और अरेस्ट भी कर सकती है. NCR, दैट इज नॉन कॉग्निजेबल रिपोर्ट, इट कम्स अंडर सेक्शन 174 ऑफ BNSS. ये नॉन कॉग्निजेबल ऑफेंस के लिए रहती है, जैसे कि अगर आपके डॉक्यूमेंट्स गुम गए हैं तो आपको NCR करानी पड़ेगी, ताकि आपके जो भी ओरिजिनल वगैरह आप उसको फिर से रीअप्लाई कर सकते हो उसके लिए, या तो आपके जो डॉक्यूमेंट्स है उसका मिसयूज ना हो, इसके लिए तो आप क्या कर सकते हो, NCR करवाते हैं. यहाँ पर जो है पुलिस को क्या करनी पड़ती है, परमिशन लेनी पड़ती है फ्रॉम द मैजिस्ट्रेट टू कंडक्ट द इन्वेस्टिगेशन. नाउ वी कम टू द थर्ड टर्म, दैट इज कंप्लेंट. सो कंप्लेंट जो होती है ये हम कहते हैं मैजिस्ट्रेट को कि लुक, जो पुलिस ने हमारा जो है FIR नहीं लिया या तो इन्वेस्टिगेशन प्रॉपर नहीं हो रही, सो हम कंप्लेंट डालते हैं बिफोर द मैजिस्ट्रेट और टू द स्पेशल और टू द सेशन कोर्ट अंडर सेक्शन 175 सब क्लॉज 3 ऑफ द BNSS. अगर हम ओल्ड एक्ट की बात करें तो दैट इज 156 सब क्लॉज 3 ऑफ द CRPC. यहाँ पर कंप्लेंट के हो जाने के बाद ऐसा ऑर्डर पास होता है बाय द मैजिस्ट्रेट टू रजिस्टर द FIR. अभी यहाँ पर जो कंप्लेंट है ना वो या तो मैजिस्ट्रेट में जाएगी अगर नॉर्मल सिनेरियो में, यहाँ तो अगर कोई स्पेशल एक्ट होगा जैसे SC ST एक्ट हो गया, NDPS एक्ट हो गया, तो वहां पर इन दैट केस सेशन कोर्ट के पास जाएगा. सो आप लोगों को सबसे पहले ये देखना पड़ेगा कि आपके फैक्ट्स ऑफ द केस के इसमें से कौन से ऑफेंसेस आ रहे हैं और कौन से सेक्शंस अप्लाई करते हो आप, एंड उसी के बेसिस पे डिसाइड होगा कि आपको कौन से कोर्ट में जाना है. JMFC यानी कि जुडिशियल मजिस्ट्रेट ऑफ फर्स्ट क्लास, पहले इनको मेट्रोपॉलिटन मजिस्ट्रेट बोलते थे, बट नाउ अंडर दिस संहिता इट इज कॉल्ड एज जुडिशियल मजिस्ट्रेट्स, या तो अगर सेशन कोर्ट यानी कि डिस्ट्रिक्ट। फिर आता है प्राइवेट कंप्लेंट। यहाँ पर प्राइवेट कंप्लेंट ये होता है दैट इज अंडर सेक्शन 223 ऑफ BNSS, या तो अंडर सेक्शन 200 ऑफ दी CRPC अगर हम ओल्ड की बात करें। प्राइवेट कंप्लेंट क्या होता है, यहाँ पर आप एक एलिगेशन डालते हो अगेंस्ट द पर्सन, सो इसमें जो इन्वेस्टिगेशन का जो स्कोप रहता है ना वो कम रहता है। वेयर इन द कंप्लेंट वहाँ पर फुल फ्लेज आपको इन्वेस्टिगेशन करने का मौका मिलता है, जहाँ पर हमारा ये रहता है रिक्वेस्ट कि पुलिस जो है इन्वेस्टिगेशन इसके अंदर कंडक्ट करे। प्राइवेट कंप्लेंट के अंदर एग्जामिनेशन होता है ऑफ द कंप्लेनेंट एंड देन अपॉर्चुनिटी इज ऑल्सो गिवन टू द अक्यूज फॉर बीइंग हर्ड। तो अक्यूज जो है रहेगा जिसके खिलाफ हम एलिगेशन डाल रहे हैं, वो आके जो है अपना से वगैरह फाइल करेगा, अपना रिप्लाई भी दे सकता है। सो ये जो थे की टर्म्स थे जो हमें समझना बहुत ज़रूरी है कि FIR, NCR कंप्लेंट और प्राइवेट कंप्लेंट के बीच में क्या डिफरेंस होता है। अगर हम देखते हैं कि वाई द पुलिस हैज़ नॉट टेकन द FIR, क्यों वो मना कर रहे हैं, क्या रीजंस है उसके पीछे। सो देर आर लाइक मैनी रीजंस बट फ्यू ऑफ देम आर लाइक, अगर आपके पास एविडेंस बराबर नहीं है, आपके पास लैक ऑफ एविडेंस है, उस बेसिस पे भी वो मना कर सकते हैं कि आपके पास सारे डॉक्यूमेंट्स वगैरह नहीं है। तो उस बेसिस में मना करता है। तो वर्क प्रेशर के ऊपर कि उनके पास ऑलरेडी बहुत ज़्यादा केसेस पेंडिंग है, तो वो आपके छोटे मोटे केसेस नहीं लेना चाहते, तो ये भी एक रीज़न होता है। या तो अगर वो इन्फ्लुएंस्ड है वगैरह, या तो अगर उनको इंक्वायरी करके पता चल रहा है कि इस केस में कुछ भी मेरिट नहीं है, तो उस बेसिस पे भी वो मना कर देते हैं। या तो अगर आपका जो पूरा फैक्ट्स ऑफ द केस है वो एज अ सिविल नेचर की तरफ जा रहा है, यानी कि वो सिविल है, यानी कि जो भी सिविल डिस्प्यूट की तरफ जा रहा है उसमें क्रिमिनल का कोई एंगल ही नहीं है, तो उस बेसिस पे भी वो मना कर देते हैं। मैनी टाइम्स वो शायद रीज़न भी ना दे आपको कि उन्होंने क्यों उस पे मना कर रहे हैं वो, तो ये भी हो सकता है ना। जस्ट इन केस अगर आपका जो कंप्लेंट होता है वो रजिस्टर्ड नहीं होता है, पुलिस जो है आपको रिफ्यूज़ कर देती है कि वो आपका कंप्लेंट नहीं करेगी, तो ऐसे स्टेज में हमारे संहिता में रेमेडीज़ दी गई है कि आप क्या कर सकते हो उस टाइम पे। तो सबसे पहला आपका स्टेप बनता है कि आप एक रिटन कंप्लेंट जो है पूरी अच्छे से लिख दें, उसके अंदर आपके फैक्ट्स ऑफ द केस होंगे। इसका जो फॉर्मेट होगा हम आगे वाली स्लाइड में देखेंगे। सो इसमें जो आपको एक रिटन कंप्लेंट देनी पड़ेगी टू द सीनियर इंस्पेक्टर। सबसे पहला स्टेप आपका यही होगा कि आप एक सीनियर इंस्पेक्टर, जो भी आपका पुलिस स्टेशन पड़ता है, जहाँ पर भी प्लेस ऑफ ऑफेंस होगा, या तो आप जहाँ पर भी रहते हैं, प्लेस ऑफ रेसिडेंट, प्लेस ऑफ ऑफेंस, वहाँ के जो भी पुलिस स्टेशन में आपका जो आता है जुरिस्डिक्शन, वहाँ पर आप क्या करोगे, कंप्लेंट फाइल करोगे इन द रिटन फॉर्म। उसके बाद भी अगर पुलिस उस पर कोई भी एक्शन नहीं लेती है, सो आप क्या करोगे, SP और DSP को जो है फिर से कंप्लेंट आपको रिटर्न में देनी पड़ेगी। ये जो है ना मैंडेटरी स्टेप्स, इसको आप स्किप नहीं कर सकते। बहुत ही अगर आपके पास एक्सट्रीम रीजनेबल ग्राउंड्स है तो ही आप ये वाले स्टेप स्किप कर सकते हो, वरना आप नहीं कर सकते हो। पुलिस को देने के बाद अगर पुलिस ने भी कोई एक्शन नहीं लिया, तो यू विल देन फाइल अ कंप्लेंट टू द SP और DSP, इन दोनों में से किसी एक को। एंड फिर यहाँ पर भी आपको कोई भी रेमेडी या तो कोई भी रिकोर्स नहीं मिलता, आपकी पुलिस आपकी FIR रजिस्टर नहीं कर रही, आपके कंप्लेंट को नहीं सुन रहे हैं, तो उसके बाद आप जा सकते हो जुडिशियल मजिस्ट्रेट या तो सेशन कोर्ट के पास अंडर सेक्शन 173 ऑफ 175 सब क्लॉज 3, सॉरी। अब इसमें जो आप पुलिस को कंप्लेंट लिखोगे ना, एक उसमें आपके फैक्ट्स ऑफ द केस आगे, और फिर उसके बाद जब SP और DSP को जब आप कंप्लेंट लिखते हो ना, तब आपको उसके अंदर एक क्लॉज और डालना पड़ेगा कि आपने पुलिस को कंप्लेंट लिखी थी बट उन्होंने कोई भी एक्शन नहीं लिया। सो ये आपको ध्यान में रखते हुए उसको करनी है कंप्लेंट फाइल। और उसके बाद अगर यहाँ से भी आपको कुछ भी नहीं मिलता, देन ओनली JMFC या तो सेशन कोर्ट के पास जाके आपको ये प्रेयर डालनी पड़ेगी कि पुलिस ने आपकी FIR नहीं दी, इसके लिए आप कोर्ट को रिक्वेस्ट करते हो कि वो जो है पुलिस को डायरेक्शंस दे कि FIR रजिस्टर करे और उसमें इन्वेस्टिगेशन कंडक्ट करे। अब इसके आगे जो है फॉर्मेट्स, उसका क्या प्रोसीजर रहेगा, वो सब जो है आपको यश बताएंगे।
Hello everyone. So format of a complaint. So when you present a complaint, तो उसके ना कुछ फॉर्मेट होता है एक जो हम एक कंप्लेंट में ड्राफ्ट करके डालते हैं. ओके, दिस इज अ कंप्लेंट विच वी गिव इट टू द पुलिस स्टेशन फॉर इट्स इनिशियल स्टेज. एट इट्स इनिशियल स्टेज तो क्या होता है उसके अंदर डेट होती है कि तुमने ये कंप्लेंट कब दिया. उसके अंदर डिटेल्स होते हैं अप्रोप्रिएट पुलिस स्टेशन के अपने जुरिस्डिक्शन के हिसाब से कि इफ यू आर स्टेइंग इन मरीन लाइन, सो वहाँ उसके हिसाब से व्हाट इज योर जुरिस्डिक्शन, विच पुलिस स्टेशन इज इट गोइंग इनटू. ओके, और योर प्लेस ऑफ ऑफिस, अगर तुम्हारे ऑफिस रिलेटेड कुछ है तो वो कहाँ कौन से पुलिस स्टेशन की जुरिस्डिक्शन में आ रहा है. ओके, यू राइट द स्टेशन, यू राइट द डिटेल्स ऑफ द पुलिस स्टेशन, whom are you addressing it to. तो इनिशियल स्टेज पे इट गोज टू द सीनियर इंस्पेक्टर, और अगर सीनियर इंस्पेक्टर रिजेक्ट करता है देन यू फाइल अनदर कंप्लेंट which goes to the DSP or the SP. Okay, then it comes to the subject. अभी subject में क्या आता है कि what are you writing it, what is this. Okay, so you write the name of the accused, उसके known and unknown associates, what all offenses are you putting on the accused person, ये सब तुम subject में लिखते हो. फिर then you move on to the facts. When you are writing the facts in a complaint, it should always be in a chronological order. Okay, you just cannot write complaint में facts in a random order. Okay, it is always better to write in a chronology so that when a police officer or any investigating officer reads your complaint, he understands each and everything properly and he can establish a timeline of the entire incident. This helps in understanding the case better, and it always helps to register an FIR and making your case strong and increasing the credibility of your case. All right. Then comes the last part. Okay. Before going to the last part, when you are drafting a complaint and you are adding the facts in the complaint, always annex relevant documents or any kind of evidence that you have with the complaint, so that every time when you present a complaint and the investigating officer or any concerned officer goes through the the complaint, and he reads all the annexures as well. He reads through the annexures, and he can interpret and corroborate with the facts that you have mentioned below. All right. Then comes the last segment, that is the applicability of the offenses. So once you have put all the facts of a case, then you write the applicability of the offenses, that what all offenses that you are levying against the accused person and how those offenses are applicable. So you explain the offenses, why an offense of 316, that is 420, fraud or cheating is applicable to the accused person, how he is liable to such offenses, and in the end you finish it with a case law stating an important case law in Indian judiciary, which is Lalita Kumari versus State of UP, which says that an FIR should be registered for any offense that is cognizable in nature. Okay, so that is how you draft a complaint. I'll just share with you guys a draft that we have for your understanding. We'll quickly go through it. So this is a draft that we had made. So here you see a date that I have written. We've addressed this to DCP Zone 4. Our complaint was initially rejected by the senior inspector. Then we addressed the same to the DCP Zone 4. We write the subject. So here you see we've addressed this to DCP Zone 4. Then we've put the name of the DCPs and the address, and we've put the subject here that we filing this complaint against so and so person, and we've levied so and so offenses. Then we go with the entire introduction of my client, and we go through the facts of the case and what my client does, and how this entire transaction came into picture. We explain the entire facts to the investigating agency, and then in the end we levy sections. These are the sections that we levied, that is 316. We explain the sections as well, what all sections that we've put, and then in the end we say that we've annexed annexures as well, that we have all these documents to support our facts and support our incidents. And then in the end we say that our client or the complainant is ready to cooperate with the investigating agency, and he's always there to give additional statements or produce relevant documents. And then in the end we produce we mention about the important case law of the Honorable Supreme Court Lalita Kumari versus State of UP, which says about putting the criminal law into motion by filing an FIR for any offense that is cognizable in nature, and then we end our complaint. So this is just a basic draft for your understanding. Moving ahead. So now procedure of a complaint before the appropriate court. So what happens when DCP or SP, PSP or SP rejects your complaint? Okay. Now what options you have? You approach the appropriate court. It might be a judicial magistrate first class, a JMFC, or a sessions court. Okay. But the draft, the format is exactly the same. So first you draft the entire complaint. You draft a petition. What are the contents of your petition? You write the facts of the case. You write the reasons for why are you filing this complaint, or the petition before this court. What were the reasons? What did the initial investigating officer say? And then when you went to his higher authority, what did he has his say on? Then you add case laws. What are the important case laws that we'll cover later in the slide? and then you add your prayer. You add prayers. You add the most common prayer is to issue directions to the investigating agency to register an FIR, or register an MCR against the accused persons, so that you can set the criminal law into motion. Okay, while drafting a complaint, it is important to make relevant people the parties to this application or the petition. So the parties would be you yourself as a complainant, and on the side of the respondents would be the state of Maharashtra, since you are challenging the report of the police that rejects your complaint. Along with that, you can add the names of the accused as well, that you are filing the complaint against these so and so accused. Okay, once your draft is complete, you go for to the e-filing account. You e-file the complaint. You e-file the entire complaint. You scan the complaint. You upload all the details of the complaint. You e-file the complaint, and you present a physical copy to the court. Once you present a physical copy to the court allots it a miscellaneous number. Any complaint application before an appropriate court is always goes under a miscellaneous application, and the original copy has to be submitted to the court along with the acknowledgement, which is the e-filing acknowledgement. Once the number has been granted, a filing number has been granted to the application, you service the same application, a copy of the application, to the opposite side. How many respondents they are, you have to submit all of them to them. जितने भी है सबको सर्विस करने का. Make a service letter. There is a format of providing a service to the opposite side. Make a service letter. Highlight the important details in it, such as the petition number, the first date of hearing, and what are you requesting them to. If it is an investigating agency, then ask them to remain present before the court with their reply, or say you need to. It can be done through hand delivery, or it can be done through RPAD, which is registered post. Since now the RPAD is shut, it is going to go through speed post, or it can be done through email or WhatsApp communication as well. Any form of service is justified. Once this step is complete, you come on the first date of the matter, and the police, if the police is present, he or she might file their say. And once the say or the police report is filed, the complainant also needs to remain present on the first day. Copy is also served to the complainant, and once the date is passed, the judge allots another day to the matter. And once the matter has been given another day, on the next date, the matter is heard by the judge. While hearing the matter, the complainant's advocate need to enumerate the facts of the entire case, and how offences are being made out, and why there is a need to register an FIR, and why the police did not, or the investigating agency did not register an FIR, and ask the judge or pray the judge to issue directions to the police to register an FIR. And once the arguments are done, then the judge keeps the matter for orders. The order may be passed on the same day, or it may be given another day to pass the order. Now, just in case the order is not passed in your favor, what do you do? If you file a revision application against the order passed by the magistrate. So this application, if the matter has been rejected by a magistrate judge, JMFC, so where do you go? You go to the sessions court and file a criminal revision application where you challenge the order of the sessions of the magistrate court. Okay, and if a sessions court judge rejects it, then where do you file a revision? You go to the higher court, which is the high court, and you file a criminal revision there. So the matters which will go to sessions court would be like if there are multiple sections and multiple acts, but if even one of those acts is a special act. For example, if there is an offense of defamation, but the person who is being defamed, okay, he belongs to a SC or ST community. So at that point also the matter would go to the sessions court, but not to a magistrate court. Okay. Then few important case laws that are really valuable and are very common and always need to be there in your complaint when you file before any court. First, we go to Lalita Kumari versus State of Uttar Pradesh. Okay, what it says in a very few lines, I'll explain what does it say. So it talks about the registration of an FIR is mandatory under section 154 of CRPC. Now it is 174. If the information received discloses a cognizable offense, any cognizable offense needs to be registered. That is what Lalita Kumari says. Then we come to Sakiri Vasu versus state of Uttar Pradesh. So this says that any person, any individual cannot directly approach High Court with a writ petition to file a complaint, or to challenge the non filing of an FIR for any offense. First, any individual needs to utilize its all statutory remedies under the CRPC, that is a 156.3, currently 175.3, before a magistrate or a sessions court, as a whichever is appropriate. Okay. Then last comes as Priyanka Srivastava versus State of Uttar Pradesh. So in this judgment, the court mandated that any application which is filed under Section 156.3 or 175.3 needs to be accompanied by a sworn affidavit by the complainant. You can just randomly not file a complaint before any magistrate without an affidavit. An affidavit is a proof saying that all the facts stated by the advocate or by myself are true and best of the knowledge, and I acknowledge all the facts that are present. Points to remember: whenever you draft a complaint or any application challenging the verdict of the DSP or DSP or the investigating agency, few things that needs to be kept in mind are understand the facts and apply appropriate sections along with its applicability. So whenever a client comes to you, you need to understand whatever he's saying, where you need to filter out all the relevant portions which is required, and put it down, jot it down in your complaint, and then apply appropriate sections. How you can apply so and so section, what angle can you make out of it, and how is it applicability, what is the applicability of the said sections, and how can you put that section into motion, and how the fact is relevant to this matter. Then you come to acknowledgement. Whenever an individual or any advocate, anyone files a complaint to the police station, or say in general to the DCP or the SP, anybody. So at that time, you should always take an acknowledgement for the same. Always take two copies, one for the investigating agents, and the other copy is for the acknowledgement that the investigating agency has received your complaint and they acknowledge the same. That many times people who are unaware about the rules and the procedures of law, they fail to take investigation, they fail to take acknowledgement, and then that hampers their case in future while filing a 156.3 or a 175.3. So what happens after you submit the complaint? So you submitted the complaint to the investigating agency, you're not getting to know what is the status of your complaint, even if the investigating agency is even investigating into your matter or conducting even an inquiry in the matter. So, in such a case, you can always file an RTI against the concerned police station or the investigating agency, asking the status of the complaint. Now, what is the advantage of filing an RTI? The advantage of filing an RTI is that it is an authenticated document which needs to be replied by any department against whom it is filed. Okay, within a period of 30 days from its filing. So when you get a reply from that department regarding the status of a complaint, you can use that complaint as an annexure or as an evidence while filing a 156.3 or a 175.3. All right, in the concerned court, showing the court that this is the status of my complaint. The investigating agency is doing so and so procedure. They have their say on this complaint. They've declared it as a civil complaint. They say we do not have the jurisdiction, or they say that there is no case being made out. This is what the investigating agency may reply to the complaint. Then the last and final is find criminal antecedents against the accused person. Before approaching a criminal court or a criminal agency or any investigating agency, you should always do a background check about the accused persons or the persons you are filing a complaint against. They might have multiple criminal antecedents. Just go on ecourts or ecourts app, and find out if there is any pending cases, or find out through your sources, or their rivals, or anybody in contact, that if they've done something like this before or any other offenses before, knowing you're the person against whom you are filing a complaint is really, really important when you file. Having a criminal antecedent, except other than the one you've mentioned in your complaint, is always an added bonus, or it is just like a boost to file when you file a complaint in court. It always shows that this person has done this offense before as well. He's committed this offense. He's being tried by so and so court before in such an offense. He is a repeated offender. He's done this before. He is liable to this offense needs to be heard. This offense needs to be registered by the so and so investigating agency. So all these things are these things which need to be remembered, and this is something that when you be in practical life, and when you start drafting complaints, when you start making a visit to the police station, when you draft a petition to the court, these things you learn when as and when you start practicing. You attend internships and do file multiple things. That is the time when you understand all these concepts, and you'll keep this in mind, and this will always be a standout than the other complaints that people file, or any common man would file. Any common man would file before any investigating agency. Another tip that I would like to give to you all would be to keep the language as simple as possible. As lawyers, it is always expected us to use complex language, use high profile English, but we need to understand that this complaint is being presented before an investigating agency, which is a police officer. And you cannot expect a police officer to have such high profile English language that we as advocates use, or we in legal fraternity use. So the language should be in such a manner that it should be understandable by the investigating agency or any officer in general who is reading this complaint, and he can interpret the same what you have written. Okay, we do not need to showcase or flabbergast our English language in such criteria, because it is always important to understand the facts of the case rather than showcasing the English or the level of English vocabulary that is being used. I think this is something which is it for filing a complaint that gets any action, and I'll open the house for questions if any.
So the first question is any resources that you all can suggest where the such formats are available?
There are not such any resources where you can get the formats. You can get them by doing internships, I guess.
And for a common man?
For a common man, you can Google few drafts, but those drafts won't be, such reliable. But it's just for making a basic understanding that ये contents होने चाहिए, ये facts होने चाहिए. But a proper draft that an advocate would draft, you would only get to know if you are interning with an advocate, a criminal advocate.
And to file a police complaint, there is no such format. You can just write a police station name अच्छे से किसको आप एड्रेस कर रहे हो, and then a detailed chronologically order में facts वगैरह, and you can present it before the police. That also works if a common man is going to present the complaint before the police. So वहाँ
Hello.
पर ऐसा कोई special format या तो ऐसा कुछ strict format rule नहीं है.
Okay.
Yes, Advocate Rashi and Advocate Surana, very well presented and all the best for your future career. I have two
Thank you.
questions. The
Okay.
first is that while drafting a complaint, is it always mandatory to mention the relevant case laws and the sections in a copy paste manner from the BNS Bear Act? And the second thing is that even I am a practicing lawyer, but the issue happens is many a times advocates practice independently, and sometimes, as Rashi pointed out, you can get it only from the senior's office. So if the PLEA or you people can just work out some drafts, because in market many drafts are available, they charge something, but actual जो बोलते हैं ना authentic जो practical
Yes.
drafts. So just we need some mechanism wherein at least the advocates can get this. This is of course not for the common petitioner, but for the advocates wherein at least he can get into these things. And please answer this, that whether case laws and sections basically every time you have to put it in.
So what happens is when you are drafting a complaint, a formal complaint to the investigating agency and not to the magistrate. So in that, the reason behind applying sections is पुलिस वाले को section मालूम होगा, but as a common person or as an advocate of that of our client, it is our responsibility to make sure that appropriate sections are levied against the offenders. So that is why we mention all those sections, and we explain कि ये sections है, ये section ऐसा कहता है, and हमारे facts के according ये sections ऐसे ऐसे बैठ रहे हैं. And why do we put a case law? Because पुलिस वाले को ये बताना जरूरी है कि सुप्रीम कोर्ट की ये गाइडलाइंस है, ये गाइडलाइंस कैसे बताए जाएंगे केस लॉ के थ्रू. And whenever we file a complaint, the first complaint that is filed before an investigating agency, उसमें सिर्फ एक ही केस लॉ हम डालते हैं, that is ललिता कुमारी वर्सेस स्टेट ऑफ यूपी, जो कहता है कि cognizable offense में an FIR का registration is mandatory
जी.
and no police officer can deny. So that is the only purpose why we put a section and case law, so that it becomes easier, it becomes binding, and it helps as a guidance to the investigating officer as well.
So Lalita Kumari has to be mentioned every time in private.
Yes, yes,
Absolutely,
you can.
absolutely.
Yes.
And one more thing, as
Hmm.
Rashi pointed out, that while drafting and filing private complaints, we have lesser legal scope rather than regular. So, can you clarify that statement? Quite confusing.
So what happens is a private complaint में जब हम इन्वेस्टिगेशन का करते हैं तो वहाँ पर लिमिटेड स्कोप होता है क्योंकि वी हैव ऑल द एविडेंस. सो वहाँ पर हमें मजिस्ट्रेट ये देखता है कि ऑफेंस जो है वो मतलब उस पर कॉग्निजेंस लेना है कि नहीं लेना है. वेर इज इन 156 सब क्लॉज 3 या तो अगर 175 की बात करें तो वहाँ पर वाइडर अप्रोच रहता है जहाँ पर हम जो है प्रे करते हैं कि FIR रजिस्टर होनी ही चाहिए एंड उसके बाद इन्वेस्टिगेशन कंडक्ट होनी चाहिए. इसके लिए देयर इज अ डिफरेंस बिटवीन अ प्राइवेट कंप्लेंट and a complaint before a magistrate.
And when the opponent party files his say as per the
Hmm.
new BNSS provision,
Yes.
so we can demand a copy of his reply.
Yes, this is your right to get the
Absolutely.
copy. So कभी भी हम कोर्ट में जाएंगे अगर opposite party files any application, any reply, you have a right to get the copy and it is mandatory. उनको देना ही पड़ेगा आपको copy
And
वैसा.
now to mention only the latest BNSS sections. No need of mentioning every time the
No, no.
old, new.
Right.
That is not required.
Yes, it is not.
No, adding to the right of receiving a reply,
जी.
what happens is at times, ये personal experience से मैं बताता हूँ. अभी recently दादर भिलवाड़ा में we moved a 175(3) application. उसमें पुलिस वालों ने अपना से फाइल नहीं किया for the past 2 to 3 days. So in such a case, what happens is जो लास्ट रिपोर्ट जो पुलिस वाला हमें देता है, due to which we are filing a complaint, that is considered to be the say of the police wala or the say of the investigating agency. If they fail to file a say when the matter is filed before a court.
Okay.
So there might be times, there might be occasions when the investigating agency do not file their say only. So in such a scenario, the first reply or the earlier reply of the investigating agency would be deemed to be their say on the present complaint as well.
The latest one which they have mentioned in
Correct.
the.
Correct. Against which we have filed the 175(3) application.
But one point just striked me, just I will take one more minute, that
Yes.
Yeah.
you said that the section has to be mentioned to strengthen our case. But can it be rectified there by the authority, or say if it goes up to magistrate? Can that section, suppose we mention 4 sections and one of the sections is not applicable, we are just trying to put pressure or some harsher sentence against the opponent. So it can be striked off, no? I think they can correct it.
Yes, that can be corrected, but the purpose of approaching a magistrate is to issue directions to the investigating agency. So at times, what happens is not all the time that magistrate is inclined towards striking off sections or get more into depth of the matter. Their only concern is with hearing the matter and understanding whether an offense is made out or a cognizable offense is made out, which is criminal in nature, and an FIR should be registered. So that is what we pray in the petition as well, that the court may issue directions to the investigating agency just to register an FIR. The striking of the section takes place when you go to the investigating agency taking the order of the court. At that time, the investigating agency or you as a complainant together may sit together and then levy appropriate sections according to the facts, and how then you may take ahead how you want to approach the present case and whatever section that you want to levy.
And every written complaint to the senior PI is in the future can be converted into a private complaint before the magistrate.
It private complaint, any private complaint to a magistrate depends upon the offenses. If the offenses is serious in nature, that is more than 3 years, a punishment of more than 3 years, at that time you cannot file a private complaint before a magistrate. So the petty offenses, minor offenses like defamation, extortion, such offenses may be filed before a magistrate as a private complaint. That goes under SW. That goes under
Yes,
SW as
got it,
summons
got
and
it, got
warrant.
it.
Yes.
Before the senior PI, if we file a matrimonial complaint, any special tips on that?
So in matrimonial cases, what happens is it is really important to check first, depending upon the side that you are representing. In DV matters, that is. So it is really important to see if you are from the husband side or the wife side. And in such cases, it is important to highlight everything and make sure that facts are pretty much clear. Few aggravating facts which might go against us may be not disclosed at the initial point of time, and things may go in our side, or may put the ball in our court, is always appreciable whenever a complaint is filed in any cases, whether it be matrimonial or a normal IPC offense or a
Yes.
special
Well
act.
clarified. Thank you, sir. Thank you so much.
Welcome.
There are two questions I wanted to ask you. The first question is, what is a zero FIR? You can explain it once, but the other question that I asked, you can explain it after that. Now, there was a case which came to me wherein this woman, the senior person had almost, raped her. There was a sexual assault, and he attempted to rape her. So basically, what had happened was this girl, she had gone for an office party. When she went, this manager dropped her home, and then on the pretext, I want to have some water, etc., he attempted to rape her. Now, this girl did not file a complaint immediately, but after a couple of days, she went to the police station and filed a complaint. Now, this would be a cognizable offense, and it should have got registered as an FIR. So she has given a complaint in writing, but I don't think it has got registered as an FIR because there doesn't seem to be any movement on that. So, what remedy do you think she can, avail of?
So answering your first question कि zero FIR क्या होता है? So zero FIR is something where you can register a complaint or FIR under any police station irrespective of where the offence is committed. So for example, अगर जो offence है वो आपका मुंबई में हुआ है commit, तो you can register an FIR in Delhi also. एंड दैट, और वहाँ पर जो दिल्ली पुलिस होगी उनका ये रिस्पॉन्सिबिलिटी होगा कि वो एक अप्रोप्रिएट पुलिस स्टेशन में उसको ट्रांसफर करे. सो दैट इज अ जीरो FIR वाला कंसेप्ट जो BNSS में अभी आया है कि आप कहीं पर भी अपना जो FIR है वो रजिस्टर करवा सकते हैं इरिस्पेक्टिव कि आपका कौन सा प्लेस ऑफ ऑफेंस है, आप कहाँ रहते हो. वो मैंडेटरी नहीं है, वो नेसेसरी भी नहीं है. एंड पुलिस को जो है FIR लेना ही पड़ेगा. वो ये नहीं बोल सकते कि नहीं हमारे जुरिस्डिक्शन में नहीं आता, वी विल नॉट टेक इट. सो वो ये वाला ग्राउंड यूज नहीं कर सकते हैं एंड फिर उनका यह रिस्पॉन्सिबिलिटी बनता है कि वो उसको ट्रांसफर कर दे. नाउ द सेकंड क्वेश्चन कि क्या रेमेडी बनती है उसकी. यश, यू वांट टू आंसर दिस?
Yeah, I'll go. So,
या
in such a situation where an attempt to rape has taken place, which is a cognizable offense, so an attempt to rape has not been defined somewhere in the IPC or the BNS. So it usually goes under, as per IPC, it was the last section, which is for offenses which is punishable with life and death, for serious offenses, last wala. And for such an offense, it would go under 354, which is sexual assault and outraging a woman's modesty, as per the facts that you've told me, ma'am. And for such a thing, if the police denies the complaint, first of all, we need to find out the status of the complaint. As I said earlier, we can file an RTI against the police station and ask for the status of the complaint, that what is the status of my complaint that I've filed. Once you receive an RTI within 30 days, if it is filed with the senior inspector of a police station, then you can approach to the higher authority, that is the DCP or the SP, as Rashi explained earlier, DCP or SP. You can file the same complaint again with them by show and annexing that the below officer or the senior inspector had taken no cognizance of this and they've done no inquiry. So I request you to look into this matter personally. And if they also deny the same, then you can approach the court. And this will always go to a JMFC and not go to the sessions court.
So yeah, that definitely helps. So if I understand correctly and I summarize what you've said is, primarily she should follow up what is the status, maybe give an RTI application to the senior person, what is the status,
Absolutely.
and find out what it is. And if that doesn't work, then approach the person higher, maybe the DCP or something. If still that doesn't work, approach the court like under the previous 156(3), she can approach and ask for an investigation to review.
इवन यू कैन ऑल्सो टेक हेल्प ऑफ द एनजीओज वगैरह जो वुमेन के लिए काम करती है और नेशनल कमीशन ऑफ वुमेन, यू कैन ऑल्सो अप्रोच देम, या तो डिस्ट्रिक्ट लीगल सर्विसेज अथॉरिटी, आप उनको भी अप्रोच कर सकते हैं कि बिकॉज इट इज़ एन ऑफेंस अगेंस्ट अ वुमेन एंड इट इज़ सीरियस इन नेचर। तो वहाँ पर भी आप जाके जो है एप्लीकेशन या तो रिक्वेस्ट कर सकते हैं, तो वो भी आपको हेल्प करेंगे टू गेट द एफआईआर रजिस्टर्ड।
So that is fine. Now there is
Yes.
another aspect which is a matter of concern. This girl stays alone, and this person has threatened her that if you tell anybody else, I'm going to come and kill you. Now that is also another reason why probably she's not pushing too much. She's waiting for the inquiry to get over under the POSH Act. She's waiting for that inquiry to get over, and then she can take that ahead. But that is also another matter of concern. So she can always put in the FIR that he threatened that he will kill me.
Yes.
Absolutely, absolutely,
Is
yes.
there some
Criminal
way
intimidation.
she can, be protected? Because if, there's nothing, if a person, if a complaint has been filed where the punishment is such a serious punishment, the person will try to harm her or try to coerce her or intimidate her and say, please withdraw the complaint or please withdraw the FIR. So you could probably say something like that also. So what can she do to protect herself?
She can always approach the investigating agency, telling them that so and so individual has been intimidating her again and again, giving her death threats, that if she takes any action against him, so he'll kill her, and ask for police protection, ask for them to take any action, because criminal intimidation, along with the section that we would have put earlier, which is outraging a woman's modesty and sexual harassment, sexual assault. These all these contents would be a part of the same complaint, and the only way is like approaching the police and being fearless about it and
Understood.
asking them for help.
Okay.
एंड यू कैन ऑल्सो गो टू एनजीओ बिकॉज वहाँ पर उनके जो होता है ना कॉन्टेक्ट्स रहते हैं, एंड देन दे कैन हेल्प यू विद द पुलिस।
So, okay, that is fine. Now, the only last thing when, what Rashi you mentioned about the zero FIR, what it is, I'm aware. What is the process of filing a zero FIR? What does one do if one wants to file a zero FIR?
It is just a normal because you have to just go to a police station, any nearby police station. You have to explain them ki this offense has been committed, and they will register your FIR, and they have the responsibility to transfer that FIR to the appropriate court. So it is normal. There's no such different procedure for that.
Okay, okay. Thank you so
Yes.
much. Thanks.
The next question, what is
Am I
the
audible?
correct time to file evidence? Should we file evidence with the complaint?
So, as far evidence is concerned, so evidence is what basically in this is the relevant documents that is supporting your facts and the allegations that you are putting against the accused person. Okay.
Yes.
So at the initial stage, it is always advisable to show documents to the investigating officer, that these are the documents. This is what I'm saying. For example, if we make a dummy situation out here, it is an offense of fraud and forgery. So and so person purchased so and so material from A. So you can annex a purchase order as one of the exhibits or the one of the annexures. Then the sale order as the acknowledgement of the sale being completed. Then WhatsApp communications can be a part of your complaint as well, that you had WhatsApp communication with the accused person pertaining to the payment of the entire transaction, that what amount is to be paid, why hasn't he paid, when will he pay, etc., etc. What is the reason he's making for the delay of the payment? You understand? And then comes the checks if he's given checks by chance. So you can annex those checks as well, that he provided us with one or two checks. So a copy of those checks may be annexed, not the original document, a
Yes.
Xerox of them. Never annex your original documents anywhere until and unless it is the time of trial before the competent court, or it is a part of the charge sheet. Always give a copy of the documents that you are relying upon and keep original with yourself. So this is how you portray you. This is how you annex documents in a complaint, and all this will be a part of the complaints which will be filed before an investigating officer. Okay, and not will be a part of the complaint or the petition that is being filed before the court. What documents will be filed before a court will be the copy of the complaint that you have filed with the first investigating officer or the investigating agency, that for say an investigate for say a senior PI, and then would be a copy of the complaint that you have filed with the DCP or SP in general, along with their reply. And except those two, other than these two documents, you can file any other additional documents that you have. For example, after filing those complaints with the DCP, you get to know before you approach the court that he has other criminal antecedents as well. So you can annex case status of those cases, and you can, if there is any order passed against the accused person regarding the same, you can annex those as well. You can annex judgments, as I said, Sakiri Vasu versus State of UP, or Lalita Kumari versus State of UP. These are the other documents that you can annex while putting in a complaint. So it is always important to put documents.
Okay. Rashi, any other inputs?
No, I think Yash has explained very well.
Okay. The next question, is it compulsory to write the complaint in the regional language? Because many a times the police ask us to write the complaint in Marathi, though we don't know Marathi that well.
So regional language का कभी कभी रहता है, so you can file it in English language also, that is also acceptable. And if necessary तो उसको translate करके, because many times पुलिस बोलते हैं कि मराठी में चाहिए, in महाराष्ट्र अगर आप हो तो, so then you have to translate and give them. But
Okay.
English works many times.
Okay.
Yes.
The next question is, can someone else file a complaint on behalf of the victim?
Yes, they can.
They should
Complainant, there
just
should be a
have the
relation. Yes.
authority and a
Yes.
relation between the victim and the complainant.
या तो रिलेशन होना चाहिए, या तो अगर पावर ऑफ अटर्नी दे के भी दे कैन फाइल अ कंप्लेन ऑन बिहाफ ऑफ द कंप्लेनेंट, दैट आल्सो वर्क्स.
Okay.
Yes.
So I am a little surprised by what you say, because in case, if supposing I witness a cognizable offense which is happening, can I not go ahead and inform the police about it?
Yes, you can go. If you have seen any offense, you can go and get a register. तो वहां पर आप बोलोगे फर्स्ट इन्फॉर्मेंट हो जाओगे आप वहां पर. ठीक है.
Exactly. So
Yes.
I was a little surprised. You have to be related, or you have to have a
नो
consent.
नो, इन दैट केस इफ अगर आपने विटनेस किया है ना, यहाँ पर अगर आपने विटनेस नहीं किया, फॉर एग्जांपल कि मैंने विटनेस नहीं किया बट समवन हैज टोल्ड मी कि ये हुआ है, सो
हाँ.
ऑन बिहाफ ऑफ दैट कंप्लेनेंट आई कैन गो एंड रजिस्टर. तो वहां पर कुछ रिलेशन होना चाहिए. बट इफ आई हैव विटनेस एनी ऑफेंस देन आई कैन गो डायरेक्टली टू द कोर्ट, सॉरी डायरेक्ट टू द पुलिस स्टेशन, एंड वहां पर मैं अपना बोल सकती हूँ वैसा.
Okay. Fair enough. Thank you.
यस या.
Okay. So with this, we come to the end of today's session. Thank you so much, Rashi and Yash. We really got to learn so much from this session. Thank you so much for sharing your expertise.
It's all right. It's all right. Thank you so much for inviting us.
Yes.
Looking forward to have you all for a future
Yes. Yes.
session. Thank you.
Thank you.